أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. Assalamu alaikum wa rahmatullahi wa barakatuh. And a very warm welcome to another edition of On the Couch on Radio 786 with me, Zainab Been. Now, On the Couch, of course, it aims to unpack, deal and discuss issues that we don't always want to address, but issues that most certainly affect you or those close to you. And of course, tonight it's Thursday and we have our weekly advice assembly, and we always inform you as to what an advice assembly is. And advice assembly is usually a weekly meeting of tenants, occupiers and activists hosted by Reclaim the City and Ndifuna Ukwazi. It is also a space to learn about eviction law and our responsibility and rights as tenants, and to stand in solidarity to prevent and resist unlawful evictions and unfair landlord practices. Social solidarity and sharing knowledge is even more essential now in the wake of the COVID-19 pandemic and massive economic hardships facing the country. Now, during this weekly on-air assembly, we will be discussing topics like what the current position is on evictions, and now that the state of disaster has come to an end, tenants who cannot pay rent, and what to do as both the landlord and the tenant, and also unlawful evictions and what to do if you are being unlawfully evicted, various ways your landlord can harass you and what can be done about them, cutting services like electricity or your water supply. Then, of course, the responsibility of bodies like the police, the court and the rental housing tribunal, where you can seek help if these institutions cannot or won't help. And then, of course, early cancellations of a lease by the landlord or the tenant. Rent is getting more expensive while people have lost income and face rising cost of living. All those and more here on Radio 786 during our weekly assembly here with Ndifuna Ukwazi and Reclaim the City. This evening's focus particularly will focus on court order and execution. What options does a tenant have thereafter? And in studio I am joined by Piwin Galo, who is the community organizer, and of course our very own Po Rabawani, who is no stranger to the airways on Radio 786. Let's welcome both. Good evening. Thanks so much for your time.
Hey Zainab, good to be back.
Always an absolute pleasure. And I'm very interested in this evening's session. The focus is quite important. It's looking at the court order and also execution. And what options does a tenant have thereafter? I want to encourage listeners that if you have any questions pertaining to the discussion, please give us a call either on 021 699 1786. You're also more than welcome to WhatsApp your comments or questions to 0786 10 11 12. So we've been speaking about the case of Megan for quite some time now, right? And at this point, the judge now has granted an eviction order against Megan and all those holding title under her. He said that the order can be executed on 1st September 2022. What does this basically mean for Megan Paul?
Essentially, it means that, unfortunately for Megan and her family, the judge has found that it would be just and equitable for her to vacate the property and return it to her landlord. So this means that Megan and her family will have to leave now that there is an official order of the court instructing her to do so. Megan can leave before the date that is on the court order, but if she cannot do so or chooses not to do so, then the order will usually stipulate that either the sheriff of the court alone or the sheriff of the court as assisted by SAPS or other law enforcement bodies is allowed to assist her, I'll say that with air quotes, to leave the property. And that basically means that they will come in and they will take her stuff out of the property, essentially forcing her to leave under that court order.
Wow. 021 699 1786 or 0786 10 11 12. Now, we've been discussing over the last couple of weeks, and listeners will remember that you can only appear in court after your landlord has filed an eviction application against you. Also, that the process is started by means of the notice of the motion and all of those things. And I think Megan has gone through all of this. And at this point, what if Megan doesn't have anywhere to go? What happens?
So Megan should have somewhere to go, because remember, no order of court can effect in homelessness. So a judge cannot hear Megan's case and consider all her circumstances, including the potential of her being homeless, and still order that she be evicted. Any order of court that does order an eviction must make provision for alternative accommodation where the where the respondent would be made homeless by this eviction. And that's where the city of Cape Town, in our instance, would come in. So the relevant municipality for wherever Megan is living, those people would have to be cited in the papers, because during the case, if it does come out that Megan has nowhere to go, then it is the city's constitutional obligation to provide her with an alternative accommodation.
Also joining us in studio is, of course, Apiwa Ngalo, who is a community organizer. Anything you'd like to add in terms of Megan's case?
I think Umpo has covered it. The city needs to make provisions for Megan. She cannot be rendered homeless. I think Umpo just hammered that in. And people should remember that an eviction should not lead to people being homeless.
Now, in last week's discussion, it was mentioned that unfortunately, where they place you, you don't really have much say or in terms of the conditions and all of those things. It may be worse than where you come from, etc. But like, what can be done in this case? Because I know that Megan also has a daughter, isn't it?
That's correct. So the personal circumstances of Megan and her family would have been placed before the court, before the judgment was made. And that's where the judge would have to consider whether the offer being made by the municipality would be suitable for Megan and her family in their circumstances. Now, in reality, that's the best case scenario. In reality, we often find that municipalities either say that they don't have any place to put evicted people, or they say that they only have one specific offer available, which means that
you don't have
there's a
any other
limited choice, you see. So, in effect, what usually happens is that because people are put in such a desperate situation, they will usually take up whatever offer is placed before them, even if it means that they are severely prejudiced by where they are placed. For instance, if you think about where the city of Cape Town places evictees, it's places quite far out, like your Volverivier, your Blikkiesdorp, and the newer TRAs, transitional housing that is. The newer TRAs in Bosasa, in Mfuleni, and in Philippi Campis, as they call it. Those are all areas or places that are some distance from amenities. It means that a child's schooling may be impacted. It means that any access to health care, especially if you have chronic conditions, may be impacted. It means that your access to transport, if you are either working or still seeking work, transport costs are invariably going to increase. So there's a lot of impact that one may face after an eviction order. But unfortunately, because of the situation in our country and because of the financial restrictions even municipalities are facing, they don't usually offer more than one alternative. Yes. So, for instance, I've had a case where my client had a child which had a very specific condition, and that meant that that child required constant access to electricity, required constant access to the nearest medical facilities, which was a designated hospital. And all of those considerations still did not make a difference in terms of the offer that the city of Cape Town put forward for my client in that matter. So these considerations are very important and must be placed before the judge, but it does not always mean that the alternative accommodation offered will cater to those circumstances.
So in terms of the alternative accommodation that the city must provide, right, are there no particular conditions or a criteria that must be met in terms of placing these people there?
So there is legislated criteria, if we can call it that, in terms of the emergency housing program. So this would be part of our National Housing Code, which is a policy that was enacted under the National Housing Act. Now, the Housing Code specifies the specifications for such emergency housing, and emergency housing also applies to people who require housing because they are evictees. And those specifications usually prescribe things like the size of the accommodation, access to amenities like water, but they don't prescribe the areas in which this accommodation must be put up. There are legal principles and practices that have come about through our case law that encourage the type of alternative accommodation given be close to the initial place where the evictee was residing because of all of these considerations that we've mentioned. And also there is a certain sense of community that has been built through those years of living in that space. So those practices are there, but it's considered as soft law in comparison to what's actually written in the code and in the emergency housing program.
Radio 786 100.4 FM is on the couch at time 22 minutes past 5 o'clock. We're talking about court order and execution. What options does a tenant really have thereafter? In studio, Apiwe Ngalo, community organizer, as well as Mpo Robiani, who joins us live in studio to answer some of the questions that you may have. Now, in terms of the duration or the time that they give you, so when you are given the notice that you have to evict, then of course it's a 30-day calendar, isn't it?
All right, so that 30-day period would apply to the notice to vacate, which is different from the court order. And I think Apiwe can just take us through what would happen in the instance where you do receive a court order and what the time periods are.
Okay, Apiwe?
Upon receiving the court order, I think what's important is that you understand what it actually says and you take note of all the dates that are mentioned in the court order. It is important that you do try to move from the place you're being evicted from. You can maybe speak to your landlord and ask them to assist you. And like we said earlier on, you can approach your municipality and ask them to assist you as well. Should you not vacate the premises on time, a sheriff is probably going to come through and ask you to leave. And if this happens, they are allowed to use necessary force to assist you to leave the premises. They can ask the SAPS to assist them, but it is important to note that this does not allow them to abuse you in any way.
Okay.
And it's suggested that you do try to find alternative accommodation and you do try to find storage for your things, because they can remove your things and put them on the street, and I'm sure you'd rather keep your things safe.
Shouldn't you be given your alternative accommodation before the period lapses, isn't it?
That's correct. So if you pleaded homelessness during the hearing, then the city must provide that alternative before the eviction date. Usually what happens is that in court, the judge or the magistrate will inquire as to when that alternative accommodation can be provided, and then they will order an eviction date after that provision is possible.
Okay.
So they will try and ensure that you would have received that alternative accommodation before the actual eviction order.
But has there ever been cases where the alternative accommodation has not been granted to the person? And what happens in a case like this?
Unfortunately, they are. For instance, if I can give you one example or one story, a specific gentleman, same issue, did plead homelessness during the eviction hearing, and was offered an alternative in one of the city's alternative accommodations. But the city failed to provide that alternative, even though he accepted the offer and submitted all the necessary documentation showing as much. And what eventually happened was that the eviction date came around. He still hadn't received that alternative accommodation. And like Apiwe said, the necessary force was used by the sheriff and SAPS to put him and his family and their belongings out on the street. And that's where he came to us with this issue. And essentially, they, having accepted the offer and the city of Cape Town having that constitutional obligation to provide alternative accommodation to prevent homelessness, there was a complete failure in that constitutional duty. And this meant that, practically speaking, this man was rendered homeless with his family, including children. Instead, what the city tended to do in those periods, this was pre-COVID, I'm not sure if the practice is continuing. What the city then did was to offer him materials to put up his own accommodation. So this is 4 sheets of corrugated iron.
And where was you supposed to do this?
And that is a very good question, because in terms of the city's issuing of kits policy, what they do is that they give you an emergency kit, as they call it, which consists of those corrugated irons, beams of wood and some nails to put together a shelter. And then you, as the evictee or the person having experienced some or other disaster, which requires you to get emergency housing, you would then have to find your own piece of land or get permission from a landowner to put up that structure in their land or their backyard. So the onus is on you as the person who has suffered an eviction or any disaster to put up your own alternative accommodation, but first to find land to put that structure up.
Here's one person who sent a message. They say that the city of Cape Town comes to court and describes the alternative accommodation as such a luxurious place that they're giving you, hinged doors, flushable toilets. Aren't these basics then that should be provided, isn't it? And when your date is reached for evictions, many times you haven't even been shown where you're going to, and then you are stranded, and the fear and panic continues. I'm continually grateful to Ndifuna Kwazi and the City for coming through for me in 2018 during my eviction, Ashura.
Thank you, Ashura. Thank you for sharing your story. And if I may just elaborate on people who have similar situations to Ashura. So what we advise during the court case is that once the city makes its offer in terms of the report that they are required to file, the next thing that must be done is a supplementary affidavit by the respondents, in this case, the people facing eviction. And in that affidavit, they would respond to the offer made in the city's papers. Part of that is to request a site visit to actually go and see the place that they want to move you and your family to, because it's very important to be able to situate yourself so that you can start planning about what your life will be like in this new area, including how far things are, children's schools, as I've mentioned before. And if you don't request that site visit, like Ashura says, you will probably get a very big shock when you eventually do move there, because as Ashura says, it's not the picture that they painted out to be. What you find there is very minimal development. It's actually just
basic.
It's those corrugated iron structures with outside shared taps most of the time. And no real access to basic services. So the flushable toilets, etc., that's few and far between. What usually happens is that you have shared ablution facilities as much as you have shared water supplies. And sometimes you have electricity, sometimes you don't. And also they tend to be very big safety issues in these communities because they are far out and because a lot of the community is unemployed. And everybody's facing a lot of risks and challenges.
So I'm just thinking of, in terms of Megan's case, particularly Megan's case, if she were to be given these sheets, who is supposed to put it up for? I'm just thinking, she's like, who's supposed to do the actual structuring of the place?
Well, the expectation is that Megan must now become Bob the Builder overnight and learn to do it herself. Otherwise, call on her surrounding friends and family or whatever support structure she has to assist her. But that's only in the case that Megan gets permission from a landowner to put up the structure. If she cannot find or get that permission to put up the structure, then she's ultimately homeless, because the city of Cape Town itself will not allow Megan to put up her structure on their land.
And it's also Megan's responsibility then to find anyone who is willing to have her on their
That's
their
exactly
property.
right.
Sure. Radio 786 100.4 FM. I'm in conversation on the couch with Pora Boani, as well as Piwin Galo, a community organizer, talking about court orders and executions, and what options really is there left for tenants after they've been given a court order. The other thing I'm also concerned about is the fact that let's say they give you find permission on a property that this is where you'll be staying. Who's going to be helping and assisting you with that structure to be put up in terms of Megan's case? But not just that, you spoke earlier about the impact that a court order and being evicted has, and it impacts on having access to a lot of things like schools, and a lot of things can be interrupted as a result of being placed in another area. And because there's not much that you can really say about where they place you. Is there any way that you can challenge you when they, let's say, like the case with your client that had a specific need in terms of health and medical access and all of those things? Could something like that be challenged in the court?
Definitely. This is why I must stress again that anyone facing an eviction, tell their legal representation, if they do have access to legal representation, or if they're representing themselves, they must be sure to draft a supplementary affidavit which answers the report filed by the city, where the city then makes the offer for this alternative accommodation. Because it's in this affidavit where you will address those challenges, including your specific needs and why this accommodation that's been offered to you won't be suitable and won't suit the needs of your specific situation, including your children, including your health needs, and all of those very pertinent considerations. And that will help to ensure that the judge does take those types of things into consideration before making an order to evict or not.
Apiwa, you'd like to add anything?
I think Mpo has covered this.
And then there's just one more comment. They take you to a place called Campus opposite the Philippi police station, and when you go to view, then you are nearly robbed. It's quite obvious that it is not a safe space for people to go to. Never mind that they move you further away from the city itself. We also want to love and work and play in the same area and not spend a fortune on these pleasures of being able to do this like other people.
That's true. So essentially, if you undergo an eviction and you have no alternative of your own, you are forced to basically give up your former life. Because as we've been saying, and as the caller has mentioned, everything that you centered your life around, that sense of community, everything that you've become familiar to or accustomed to, and all the amenities that you need to have a regular life, or at least access to a chance of having a regular life, those are effectively taken away from you if you are placed in a position or in an area where it's too far and too expensive to continue your former life. So it just sets you back in a sense that, yes, you've been evicted, but you don't really have an opportunity to start rebuilding your life and getting back on track, because now you have additional hurdles or additional challenges that you have to contend with.
What else is important for people that is in this position, the position that Megan is in?
I think another important thing for people like Megan, during the eviction proceedings, be very careful not to be pressured to accept any offers. This is from the first stage. These are from the initial stages of the eviction applications right until the offer of alternative accommodation. Because what we usually see is that the applicant's attorneys, which in most cases would be a landlord or a landowner, they like to pressure you into settlements. So they will catch you before the hearing, usually at your first appearance, and say to you, listen, we don't need to do all this because if you lose, you will have to pay all the legal costs of this application. And that's going to be very expensive. You don't want to be put in that position. So let me do you a favor. I'll give you 2 months. I'll give you 3 months, or I'll give you a month, and you just leave so that we can avoid this whole process. And usually people who aren't aware of the protections that are in the law, or people who are quite frightened and traumatized by this whole process, they would look for an easy way out, and they usually think that this is the only option that they have, but this is not true. There are very many protections that exist in our law, especially if you have particular circumstances covered in the PI Act. If you are a female-headed household, if you have children, if you live with elderly people, or if you have people in your household living with disabilities, there are special considerations for all these categories, and you may find that there may be a level of protection for you, and you shouldn't be pressured into a situation where you agree to move out without having an alternative and without making a plan.
Just a reminder to the listener that with about 3 minutes left to the program, there's also one more comment on WhatsApp on 0786 10 12. It says, so what about the landlord's expenses if rentee does not pay?
All right. And this is a very valid question, because we also can't expect the landlord to put up the costs indefinitely for someone, let's say, who is unable to pay rent. So what we advise in that situation, especially for low-income landlords who depend on rental income for their sustenance, what we advise is that landlords in that situation can approach the courts for a separate process. I think you covered this last week, the rental interdict.
Yes.
And in this way, you're now approaching the court to help you recoup the monies owed to you. In that sense, then you won't have to bear the burden of the costs of a missing rental if that option is available to you. But we must remember that this is a separate process from the eviction application, because the rental interdict speaks to the rental monies due or owing, whereas the eviction application speaks to having the person or the tenant removed from your property.
I think, Zainab, it's also important to remember the step of meaningful engagement. I think that sometimes people miss payments. Maybe they've received, they're not getting as much as they used to. And I think through conversation and through discussions, the landlord and the tenant can come to an agreement of maybe paying less rent, or saying that when you do get a job, will you be able to pay for the months that you haven't been able to pay. So through meaningful arrangement, evictions can be avoided, and more, solutions can be found between the tenant and the landlord.
Okay. Now, we are unfortunately at the end of the discussion, and of course due to a time constraint, but just a reminder to the listener that if you would like to find out more, you can find Ndifuna Ukwazi on Facebook and Twitter. Also, you may visit www.evictions.org.za, and of course the housing clinic line, that is the Ndifuna Ukwazi housing clinic line at 0662 352 9372. That's 062 352 9372. Or you can email ntombi@nu.org.za if you wish to find out more. And also you may also take note that the law centre, the other law places that you can also contact, and in terms of assisting you free of charge, is the Ndifuna Ukwazi Law Centre, UCT Law Clinic, the Women's Legal Centre, as well as Legal Aid. And organisations have criteria for seeing if you qualify for these free assistance, and keep a record of all your attempts to secure legal representation. And that's just a reminder. And then also, of course, we know that we've been mentioning for the last couple of weeks that there is the Advice Assembly, the 10-week program that started on 8 14th May between 5 and 7. It is happening at Bertha House, 6769 Main Road in Mowbray. But for more details, and if you want to know more about the law that governs evictions, it is absolutely free. Contact them at 065 993 1324. That's 065 993 1324. And of course, you can email yusra@nu.org.za. That's how we come to the end of another weekly assembly worth and for now Kwazi. And of course, we say many, many thanks to Apiwan Galo as well as Mpora Bawani for joining me in studio this evening. And there are still more questions around unlawful evictions by community, and maybe that is something that we can do in the next session, inshallah. But until then, thanks so much for your time, and assalamu alaikum wa rahmatullahi wa barakatuh.
Radio 786. Hear the difference.